Good morning. Thank you for joining this webinar, which is entitled Overview of Best Practice and Introduction of a New Workbook for Creditors Voluntary Liquidations. This webinar is being presented by myself, Derek Wilson, and Sarah Jane O'Keefe, a Director with Assets in Dublin. Both of us produced the new CVL workbook for Chartered Accountants Ireland, which focuses on the statutory procedures and practices for conducting statutory meetings and reporting to committees of inspection throughout the period of a liquidation. I was formerly an insolvency reviewer, working for many years with Chartered Accountants Ireland. And during the period of doing that work, many IPs would ask why there wasn't a workbook or work pack that would assist them in dealing with creditor voluntary liquidations. So now we've been able to produce one, which basically covers letters, notices, meeting procedures, minutes, etc. And this is also should ensure sort of compliance with legislation, statements of insolvency practice, and best practice. Within the work pack, there's also some detailed notes explaining the requirements of the various aspects of the procedure. So in the session, obviously covering this brief introduction, but we'll also cover the validity of appointment, the initial meeting process, annual meetings, final meetings, reporting to creditors and committees of inspection, the statutory CRO filing that's required, section at the end on approval of remuneration, and then we'll try and do some questions and answers at the end. Basically been agreed that if we can't address all the questions that we may get during the webinar, then we'll try to feed them back in some sort of help sheet or update that comes out from the Institute. The workbook basically shows examples and a connection between the various aspects of the notices basically given out, ensuring that proposed resolutions are stated in the notices and the business of the meeting is clear to the participants. There's obviously the covering letter and the forms of proxy that should go out. Obviously, the general proxy is there to allow an alternate to attend a meeting on your behalf or appoint the chairman of the meeting. Well, the general proxy itself doesn't have actually any voting instructions. That's basically covered by the special proxy, which should include details of the resolutions that's been put to the meeting, therefore allowing each creditor to either vote for, against, or abstain from any proposed resolutions for any of the meetings that are being covered. The liquidator obviously can't use a general proxy to approve the basis of his or her remuneration, and therefore that basically has to be dealt with and addressed by the special proxy form. The styles that are there can be easily adapted for other resolutions and basis of remuneration, as the principles and approval for each are broadly similar. The CVL workbook styles and templates cover the whole statutory requirement process from the extraordinary general meeting right through to the final meeting, and it allows IPs to basically adapt or incorporate the points that we've included in them into their own existing templates. The webinar is obviously going to highlight the key aspects of each stage of the liquidation. I will cover the extraordinary general meeting, the meeting of creditors, and the committee of inspection. And then Sarah Jane will go over accounts of acts and dealings, annual meetings of committee of inspection, annual meetings of creditors, CRO filing, post-annual meetings, and the final meeting process. Subject to our timing, I'll revert back with a section on remuneration, and then finally we'll have the questions and answer session. So the extraordinary general meeting obviously kicks off sort of the whole process. The purpose of the meeting is to resolve that the company cannot, by reason of its liabilities, continue its business, and it be wound up by the creditors by means of Creditor Voluntary Liquidation. A slight misnomer, because it's saying the creditors, but actually it's not. It's only the members that can really initiate a CVL. The purpose of the meeting obviously is to appoint the members' nomination for a liquidator. So it's the person that they will speak to and engage with to start the process. And the meeting members cannot pass any resolutions, which is important to remember, as to the liquidator's post-appointment remuneration, other than to approve any remuneration to be paid from third-party funds. This was something that I quite often would see when I was doing monitoring visits, people incorporating a resolution saying that the liquidator would be remunerated on the basis of a time cost resolution, but actually that's not something that the members have within their powers. The director of the company obviously can call an extraordinary meeting whenever they think it's appropriate to do so. 21 days notice is required under most companies' articles of association for a general meeting to pass a special resolution to wind up the company. However, members can agree and consent to shorter notice basically being agreed. Also, the directors of the company have to prepare a full statement of the position of the company's affairs, together with a list of creditors and amounts due to each creditor, to lay before the extraordinary general meeting and the subsequent meeting of creditors. Notice of the resolution to wind up a company and appointment of a liquidator must also be advertised in the Irish Official within 14 days of passing such a resolution. Having held the extraordinary general meeting, and obviously there are examples of the notices in the work pack or workbook, notices, minutes of meetings, resolutions, etc., to support this stage of the process. We then moved, having members now having appointed their resolved that the company should be wound up and appointed their nominee. We then moved to the meeting of creditors. Both meetings generally happen on the same day. And this is where it's important to really make sure that the notices of the meeting of creditors basically allow you to achieve some of the main aspects of this meeting. So the purpose of the meeting are obviously for the appointment of a liquidator. Now that can be the member's nominee, or the meeting of creditors can nominate an alternative person to be liquidator, in which case it's the meeting of creditors nominee elected by any proxy voting or voting poll that then becomes the appointee for the purposes of the liquidation. One of the other purposes of the meeting is obviously to form a committee of inspection, and one of the main duties of the committee of inspection is obviously then to approve the liquidator's basis and amount of remuneration. And if a committee of inspection is not formed, then we should try to seek to pass a remuneration resolution. So could we go back one slide? Sorry. So, sorry, I'm not in control of the slides, but they're being controlled remotely. So if a committee of inspection is not formed, then what we'd seek to do is pass a remuneration resolution. So the key points in terms of the meeting of creditors are that the notice of the meeting must be advertised in at least 2 newspapers, daily newspapers circulating in the district of the registered office of the company. Notice in writing of the meeting must be sent to creditors and either attach a list of those creditors or provide details where a list of creditors can be inspected. The directors of the company obviously shall appoint one of their number to preside at that meeting, and that person will be chairman of the meeting, although normally would be assisted by sort of liquidator. If the creditors and members of the company, as I said, nominate a different person, then it's the creditor's nominee that shall apply. And notice again of the resolution to wind up the company and the appointment of confirming the appointment of the liquidator has to be in the Erishofigal within 14 days. There's then a requirement to file Form G2 with the CRO within 15 days of passing the resolution, and Form E2, notice of appointment of the liquidator, within 14 days. The key aspect and one of the main purposes of the meeting of creditors is basically A, to get a liquidator appointed, but B, to ensure that the liquidator is remunerated for the work basically that's done during the course of the liquidation. So if there's no committee of inspection established, then this is the opportunity to try and pass a resolution. However, it's important that this resolution and the fact that you're proposing to do so is incorporated within the notice of the meeting. In the past, this is something that wouldn't necessarily have happened, but it is important to make sure it is done so that it can be considered, so that all creditors are on notice that in the event of committee of inspection is not appointed, that such a resolution will basically be put to the meeting. And effectively, by putting them in notice, everyone is invited to attend and vote regarding any such resolution. They're able to then ask questions of the liquidator or seek additional information in relation to any proposed resolution. And they've obviously got a voting proxy form, a special proxy that they can use in the event that they choose not to turn up. But at least you put them on notice that this is part of the purpose of the meeting, and thereby have a valid remuneration resolution appointed. Otherwise, if this isn't done, then you're effectively going to have to go to another meeting at some point to basically try and either appoint a committee of inspection or try and pass some time cost resolution or remuneration resolution, which might be, up to an annual meeting. But that then means that the liquidator is proceeding with some uncertainty as to the basis and the amount that he's likely to receive for his fee as liquidator. So if we can now just go on to sort of the committee of inspection. So the committee of inspection basically is a useful group of individuals to assist the liquidator with the liquidation. The committee represents the interests of the creditors and members of the company being wound up. They approve the liquidator's fees and expenses, and they can also agree course of action to be taken by the liquidator to pursue recovery of assets or abandon assets that are not economically viable to recover. The composition of the committee is a combination of creditors and members, and the creditors of the company can appoint up to 5 people. The committee, members of the company can appoint up to 3 people. The committee cannot have more than cannot have more than 8 members or less than 2. Once established, the committee members decide when and where to meet and how often to meet, although generally the liquidator would call meetings when he considered it appropriate to do so. Generally, there's a requirement for more meetings at the outset of the liquidation when there's obviously a lot happening, and thereafter they may become less frequent. Notwithstanding this, however, there is a requirement to hold an annual meeting of the Committee of Inspection each year. and and that must be done within the prescribed time period, which is within 28 days of the anniversary of the liquidation. It's important in terms of the timing of this meeting, and Sarah Jane will touch on this, with relation to the submission of Forms E3 and E4, which we'll talk about later. For a valid meeting to be valid, more than half of the committee members need to be present, at the meeting. I'd highly recommend, if where possible, you try to get a committee of inspection. As I say, a minimum of 2 is required. Generally, when you're approached to take on a liquidator, it's generally a creditor, might be another accountant or lawyer who acted for the firms, maybe one of the creditors. You should try, where possible, to get them to agree to become a member of the committee. The big advantages on having a committee of inspection is that you're dealing with a smaller number of parties rather than the whole body of creditors. The purpose of the committee of inspection is to stand in the place of the general body of creditors, and they represent the creditors. When you have a committee of inspection, you then have a requirement to hold annual meetings of the committee of inspection, but there then is no requirement to hold annual meetings of creditors. This obviously helps you because you're engaging with a smaller number of people who are engaged in the process and like to be more involved and more knowledgeable through their involvement of being in the committee. It also significantly reduces the costs of printing and postage of notices, copies of accounts of acts and dealings, etc., that would require to be issued where annual meeting of creditors being held. It's easier to explain to a smaller number of people the difficulties or the issues that you're dealing with, to discuss this, and then, if necessary, negotiate in terms of remuneration, which the liquidator is seeking. Another significant advantage is obviously the committee of inspection can sanction or approve actions the liquidator wants the committee of inspection to consider. This is particularly important when dealing with difficult issues that could be challenged by a creditor or a director. Now, at that point, I'm going to hand you over to Sarah Jane, who will then take you through the next few slides.
Thank you, Derek. This leads us nicely to post-appointment matters to be dealt with by the liquidator. The handbook provides various examples of letters to be sent where a committee has been appointed or where no committee has been appointed. The first meeting of the committee or the creditors should be held as quickly as possible after the appointment of the liquidator. This allows the tone to be set, and in particular, the method of remuneration to be agreed if it has not already been agreed and approved during the initial meeting of creditors. The initial letter to creditors post-appointment should indicate the resolutions passed for anyone who was not in attendance at the initial meeting, and the likelihood of any dividend paid in the liquidation. I understand this might be quite difficult as you've just been appointed as liquidator. However, the statement of affairs is available at this stage, and therefore you may have an indication of what assets can be realised during the liquidation to give some sort of indication within your letter. The letter should also set out the insolvency practitioner's GDPR statement showing how information is stored and to be held. This is highly important and become more topical more recently, where we are storing, as liquidators, we are storing employee information, be it bank account details, PPS numbers, and also information regarding directors. So therefore, it is important just to set that at the outset. The handbook also provides information on the first meeting of the Committee of Inspection, which Derek has dealt with, and what details should be discussed. Other matters for the liquidator to consider the first week of their appointment is to gather as much information as possible on the directors, books and records, employee claims, securing the assets, and bank accounts, just to name a few. Derek has briefly discussed on the statutory matters post-appointment, including the filing of the E2 notice of appointment within 14 days, the filing of the G1 or G2 within 15 days, and the obligations of your publication within Irshfagul also. This now leads us nicely into the section of the pack around the accounts of acts and dealings. So what does that really mean? An account of the liquidators' acts and dealings must be prepared for an annual and final meeting of creditors and committee of inspection. This can be prepared on an ad hoc basis when required, in particular if a committee of inspection meeting is warranted prior to an annual meeting. It should include a receipts and payments account. This will be up to the liquidator to decide what format the receipts and payments account takes. Some firms have a software that will produce this, and others have more of a simple approach, be it an Excel spreadsheet. Whichever method you do use, just make sure that there's notes and descriptions to back up for each transaction, so it's retained on file if needed in the future. A summary of significant matters to be dealt with the preceding year, along with the details of the progression of the liquidation. This allows the liquidator to showcase the work that has been done. At the same time, it will provide a backup in circumstances where fees are to be approved. Details of any outstanding matters might be included also, for example, sale of assets, a CEA decision pending, or adjudication of creditors' claims, just to name a few. If trying to get fee approval within your report, just make sure that it is SIP 9B compliant, which Derek will touch on later on as well, just in relation to the summary of time costs and details of any fee approval sought. The SIP 9B aims to ensure transparency and fairness in the remuneration of insolvency practitioners, and practitioners must provide detailed information about their fees and expenses, including the basis of their charges and the work performed. Other practical matters to consider when preparing the account of acts and dealings is that a copy of the account should be issued with the notice of the meetings, in particular where remuneration is being sought for approval. Along with the special proxy voting form should be sent, giving the option to vote for, against, or abstain from any resolutions. Just a point that Derek touched on as well, that just if fee approval is being sought, it's important that if a special proxy is being used to appoint the chairperson at the meeting, that the liquidator should practically not chair this meeting and should have an independent third party chairing the meeting. So this brings us nicely onto the next slide, to our annual meetings of the Committee of Inspection, which is dealt with under Section 680 of the Companies Act. The main purpose of this is to present the account of the liquidators' acts and dealings in the previous year to the Committee of Inspection, seek approval of remuneration in accordance with the remuneration resolution previously passed, propose any other resolution that the liquidator wishes to obtain for approval, and obtain consent to seek directions from the committee for any proposed course of action by the liquidator, for example, legal actions or write down in debt, for example. There's no requirement to hold an annual general meeting of creditors if a committee of inspection is appointed, unless instructed so by the committee itself. The annual meeting must be held within 28 days of each anniversary of the liquidation, giving 7 days notice of the meeting to the Committee of Inspection members, and as mentioned, prepare and present an account of the liquidators' act and dealings at the meeting. We'll then move on to where a Committee of Inspection is not appointed and an annual meeting for creditors must be held. Similar to the COI meeting, the liquidator must present an account of the liquidators' acts and dealings, must seek approval on remuneration, propose any other resolution that he or she wishes to obtain approval for, and obtain consent for seeking directions from creditors for any proposed course of action to be taken by the liquidator. Again, similarly, it must be held within 28 days of each anniversary, giving 7 days notice to the creditors, and prepare and present an account of the liquidators' acts and dealings must be sent with that also. So what happens then once the meetings are held, and what are the liquidator's statutory requirements following the meeting? This leads us now on to the CRO filings, and the first form we'll discuss is the Form E3, which needs to be filed with the CRO after the annual meeting. So the form details transactions for the last 12 months period from the last anniversary date. The Form E3 must be filed within 7 days of the meeting of creditors or the committee of inspection. The form must attach an account of the liquidator's acts and dealings presented at the meeting. If the liquidator does not attach this, there is a box available on the form where you can insert a meaningful summary of the information provided within the relevant section of the form. The form also requires the nature of realisation and disbursements to be attached to the form or listed within the form itself. If you generally have some large number of transactions, an Excel spreadsheet attached to the form, you can upload that to the form, which might be helpful and save some time in terms of manual entries into the form itself. The form will be signed by a liquidator or joint liquidator where appropriate, and only the signature page needs to be uploaded to the CRO platform, as the form is already drafted there and already on the file. So it's just the signature page that needs to be uploaded. The next form required is the Form E4, and this, similar to the E3 form, the purpose of the form creates a public record of the receipts and application of the funds in the liquidation. It allows interested parties to check the public record on the CRO and obtain details of the liquidator's progress to date. The Form E4 has to be filed within a prescribed time period, irrespective of the timing of the annual meeting, which Derek touched on earlier. So the first E4 form must be filed 12 months for a 12-month period post the anniversary date. The second is due then 6 months thereafter for the period of the liquidation. And then just to note, if you're calling a final meeting and there's a shorter period since the last time you filed your E4, you do have to file an E4 for that shorter period. The E4 must be sworn by a solicitor, which I know brings quite contentious to insolvency practitioners over the years, and is currently being looked at by various committees at the moment. As I know, Derek mentioned before that the UK don't have that requirement, so it would actually be good to get rid of that requirement here. And if the filing of the E4 and E3 together, just practical recommendation would be to hold it within 14 days of the anniversary date, just so that sometimes it could be missed that if you're holding out the E4 for your E3 to be filed, then your E4 may be deemed late depending on when your AGM is taking place. So once the liquidation is concluded, what are the next steps then? The liquidator is required then to call a final meeting of creditors and members. The purpose of this meeting is to present an account of the liquidator's acts and dealings, to seek approval of remuneration drawn on account in accordance with any resolution previously passed, and purpose of any other resolution the liquidator wishes to obtain, for example, destruction of books and records. It is important just to note that you should not be relying on seeking fee approval at your final meeting. I know it's not always possible to do it beforehand, but where possible, try and get it done at your annual general meeting, or where a committee of inspection is in place to do it at those meetings also. So just to take on that point. So we call a final meeting, excuse me, within at least 28 days written notice to all creditors and members. There's no need to place an advertisement in the newspaper, and we prepare and present an account of the liquidator's acts and dealings, and just as mentioned, good practice to send it with your notice and proxy. And then the forms that need to be filed are the E5 and E7 forms with the CRO 7 days from the date of the meeting. The E5 will list the accounts of the liquidators by various line items and various descriptions. There is a bit of duplication contained within the form, and the CRO are currently working on amending that form, but for now you will see a bit of duplication. And the E7 just shows whether the actual meeting was held or just summoned and at what date. So they all need to be filed with the CRO. Once the forms have been filed with the CRO, it is the registration date of those forms submitted that starts the 3-month clock for the dissolution of the company. This can be voided within 2 years under Section 708 of the Act and can be done by court order. Then the company then returns to the normal liquidation status. In addition, the liquidator must keep books and records for a period of 6 years post-dissolution. So just a couple of points just to reiterate before I pass you back on to Derek is that if a committee of inspection was appointed, annual meetings of creditors are unlikely unless instructed by the committee. And if no committee of inspection was appointed, it is not recommended to seek remuneration approval at a final meeting of creditors in case the meeting does not have quorum. So in that case, I'll pass you on to Derek, who'll talk about the remuneration. Thank you.
Okay. Right, thanks, Sarah Jane. Okay, so while we've been looking at that, there's actually a couple of questions come up from the Q&A session, and whilst there is a Q&A session that will at the end, I'll try and deal with a couple of these points because they're at the sort of earlier stage of the process. So one of the questions that we've received regards pre-appointment fees, and the person's pointed out that quite often a substantial amount of work is required to assist the company and directors in calling the meeting. It might be involved in helping prepare the statement of affairs, etc. And the question being asked is, what's the position regarding potential remuneration for this service? The answer is that you're assisting the members to begin the process, and there's no issue effectively in being remunerated sort of in relation to this. The key point is that this is effectively something that you agree between yourself and the members, and that should basically be noted, and confirmation of any payment recorded in the minutes of the extraordinary general meeting. It's also important, however, it is important to make sure that any fee is paid before the meeting of creditors, because otherwise you would need to get the creditors to agree the pre-appointment fee. So basically you should try and agree in advance. It should be commensurate with the work involved, and should be paid in advance of the meeting as approved by the members. Another question has come up regarding committee of inspections, and basically saying what happens if you've got sort of insufficient numbers to have a committee of inspection. Well, unfortunately, if you don't have if you don't have sufficient numbers, the minimum being 2, then you just have to proceed without a committee of inspection and have any resolutions approved by the creditors in general at an appropriate meeting. The key sort of aspect to this, and the work pack that we basically produced is effectively showing you what's required at each stages, and basically working through each of those stages. And obviously the work pack itself is very much focused on making sure that there's compliance with both legislation and statements of insolvency practice, together with elements of best practice. Whilst at the moment the threat of any imminent monitoring visits has receded, it's still important to make sure that you do remain compliant, particularly in relation to remuneration approval, because this is an element where potentially a creditor or director, could lodge some complaint against the member with the institute, which obviously, causes, substantial inconvenience, if nothing else. So moving on now to sort of remuneration. Now, this in itself is obviously, it could be quite a significant, topic in itself. But broadly speaking, remuneration is determined by the Companies Act 2014, which determines effectively who can approve the basis of the remuneration and the amount, and Statement of Insolvency Practice S9B, which states that the information is to be provided by those approving remuneration in periodic reports. In terms of remuneration, the Companies Act, doesn't have a huge amount of sort of information and requirements as to what needs to be provided or what the process is for approving remuneration, other than stating who can approve the remuneration. The detail really is in the Statement of Insolvency Practice S9B, which, as it's been revised over the years, has imposed more and more requirements on insolvency practitioners to provide information when seeking approval. The Companies Act basically says that remuneration can be approved by either a relevant percentage, by reference to time expended by a liquidator, which is by far and away the most common method of being remunerated, or otherwise by reference to any method or thing. The most common non-time cost resolution is basically where fees are being paid by a third party due to insufficient funds, or being provided with an indemnity, or basically getting a fixed fee for carrying out the work. The Companies Act says that the terms upon which the liquidator has entitled to remuneration should be in terms agreed in writing initially between the liquidator and the Committee of Inspection, or in the event that there is no Committee of Inspection, then by a meeting of creditors, failing which by the court. Now, I'm well aware that in Ireland the costs of going to court, particularly just to get remuneration approved, is substantial, and other than exceptionally large cases is basically not practical. So to all intents and purposes, what we're really most likely to be dealing with is either by a Committee of Inspection or by the creditors. But the key point is that these are the only bodies or groups that can actually approve remuneration, not directors, not the members. It's either a Committee of Inspection, it's the creditors at a general meeting, or by reference to the court, either because you've been unable to get approval from the committee or the creditors, or it's been challenged by the liquidator. There's quite substantial notes sort of within the workbook, sort of in relation to this and each of the other sections that we've basically spoken about. The key thing again is that the liquidator shall, as soon as practicable, after his or her appointment, seek to fix the basis of remuneration. And that said, once fixed, it can be varied at a subsequent meeting by a Committee of Inspection or by meeting of creditors. The Statement of Insolvency Practice S9B basically includes a summary of the key requirements of the Companies Act. It's a very well written Statement of Insolvency Practice. It's easy to read, easy to understand, and certainly should be to a large extent your first area to focus on when looking at sort of this area. As far as remuneration is concerned, The principles basically are that the payments to the principal, as in being the liquidator or his or her associates, should be appropriate, reasonable, and commensurate with the work necessarily undertaken. Those responsible for approving remuneration, be it the Committee of Inspection, creditors, or in the report to the court, should have sufficient information to make an informed judgment as to the reasonableness of the office holder's requests. And requests for additional information and payments should be considered and the merits of the particular circumstances of the case. And that remuneration should be charged on a transparent basis and payments made in line with the approval process and resolution that was previously approved. The office holder should disclose all payments of remuneration and expenses arising from the appointment of his or her associates, and should disclose any personal relationships with interested parties, which could result in a conflict of interest. When fixing the basis of remuneration, as I say, it's important that you provide those you're asking to do it with sufficient information, taking into account the circumstances of the case. And where remuneration is sought on a time cost basis, then you need to provide details of the minimum charge out rates, current charge out rates, split by grades of staff of those likely to be involved in the process. You should also provide details of any work that's been done or is proposed to be done by third parties, that work's been subcontracted by the liquidator, work that could be done by his or her own staff. And if that work has already been done, you need to provide details of the charge in the period and what has been achieved and how it was achieved, sort of in relation to this. One of the key differences that really come about with the evolution of the SIP is that the early versions of the SIP that came in around the time the Companies Act, both prior to and just post the Companies Act 2014 until they were updated, was that the phrase was that you should, if asked, be, and I'll paraphrase here, sorry, you should, if asked, be prepared to provide information in relation to remuneration, work done, etc. Whereas now the obligation is that you have to provide that information to those that you're asking to seek approval. And as Sarah Jane's commented earlier, this is normally done on the basis of information when you provide an account of your acts and dealings. Now, in terms of an account of your acts and dealings, whilst there's a requirement to call meetings and there's a requirement to issue notice of the meetings, there's also a requirement to prepare an account of acts and dealings to prepare before any meeting of a Committee of Inspection or any meeting of creditors. The legislation does not state, however, that that has to be provided to individual creditors. However, if remuneration is being sought at an annual meeting of creditors or a final meeting of creditors, then in order to comply with the Statement of Insolvency Practice S9B and provision of information, you actually have to send that account of acts and dealings with notice of the meeting so that creditors or members of Committee of Inspection can consider the information that's being provided and decide to vote for, against, or approve any remuneration resolution. After you've fixed your remuneration, the basis of your remuneration, then it's important in periodic reports to provide details of the time, if it's a time cost basis that the remuneration is being paid on, is to provide details of the time cost for the period, the charge out rates for the period, and the time spent and the average charge out rate, sorry, I should say, for the period. However, The practitioner should also consider if further disclosure is required or is requested by creditors, in which case that the work done should be split down by grades of staff and analysed by appropriate activity. This is usually relevant in larger and more complex cases where higher fees are being sought. Where remuneration is being discharged by a third party or the petitioner, the quantum and basis of the fee disclosed should be disclosed by the office holder in the first report to creditors and in each subsequent report, so it's clear that this is the basis of remuneration. There are several bases which a member or liquidator can be sorry, I should say liquidator. When I say a member, I mean a member of the institute, where a liquidator can be appointed and paid on remuneration. The most common one is obviously the time cost resolution, which we've covered well in the work pack, but there are other bases that we sometimes see. The first one quite often is obviously fees being paid by a third party because there's insufficient funds to fund the cost of the liquidation, in which case it's important that is actually disclosed. That said, if there are still some funds, although insufficient to pay the cost of the liquidation, it could result in the liquidator being paid some fee from assets that are realised in the liquidation. It's important that element of the fund is still approved. So if there's absolutely no assets whatsoever, then it's fine to just report the fact that the fee has been paid by a third party, who's paid it, and the amount. If, however, there are likely to be some funds in liquidation, these can obviously be applied firstly against any disbursements or expenses of the liquidation. However, if that would leave a small sum, then that can't just be withdrawn by fees as a fee, even if you've agreed a fixed sum with the members or directors, because they can't approve a fee post-appointment. Therefore, it's important to get a resolution. So even if you have a case where there's you're pretty sure there's not going to be an awful lot by way of assets available to pay any aspect of your fee, it's still worth passing a time cost resolution at the early stage in the event that additional assets are recovered. The other one that sometimes happens is that people obviously get indemnities. So you take a case on, you're not sure there's going to be sufficient assets to pay for the liquidation in full, and you agree with a third party that they'll indemnify you for part or all of your fee. Again, it's important that that is intimated to the creditors and that you get approval for the element of the fee that you are able to withdraw from funds available, and then revert to the third party for the balance of any funds. I have had questions in the past, people saying, well, how do you deal with that? If there is some uncertainty, I've seen, good practice where basically people, will ensure that they have the funds and retain the funds basically in their client account, not forming part of the liquidation account, because these are third-party funds and they're transferred as appropriate and as agreed. And then finally, there's obviously quite often we see just a fixed fee, and if you've got a fixed fee approved, again, sometimes that amount is that you get creditors to approve it, the committee to approve it. It reduces the requirement for additional information and approval at different stages. That said, it still has to comply with the principles that the fee is actually reasonable and commensurate with the work done, and would still have to be explained in each of the reports for annual meetings. So that's taken us to about 10 minutes to go, and I think we can move now on to the questions and answer session. I'll go through some of the questions that we have just now, and maybe Sarah can join me at this point. So, just going through a couple of the questions. We've had one regarding pre-appointment fees, which I've covered. Right. Okay. So, I had a question here. Someone's asking, what happens if you don't have a quorum of 3 at a creditor's meeting? Can the liquidator be appointed? Well, the answer is yes, because what happens is that the liquidator is obviously appointed at the EGM, being the member's nominee, and therefore, when you go to the meeting of creditors, whether the meeting is quorate or not, as long as the meeting is properly held, properly intimated, then the member's nominee is obviously the person that's appointed and confirmed as liquidator. There's a question here basically come up saying, can the meeting of creditors be held on Zoom if the directors cannot be in attendance due to personal circumstances? There were provisions in place in relation to COVID, which allowed for meetings to be held not in person. However, my understanding is that has now basically expired. Am I correct in saying that, Sarah? Sarah Jane?
You are, yeah.
Yeah. So the answer really is that no, meetings now really have to be sort of in person, and it's important to get a director to be there, sort of in attendance. It is actually one of the key aspects to allow creditors to question the directors as to the circumstances leading up to the appointment. I think it's really down to the individual circumstances, of the case and the timing. I mean, it may be that meeting just has to be deferred until the director is available to be at the meeting, or seek legal advice, which is the fallback.
Check the constitution of the company as well, just to ensure that if they allow for video conferencing or teleconferencing, that might be a way to get around it. So just to take note of that.
Okay, another question has got, and again, it's for an MVL, which converts to a CVL, and if there's only one creditor who does not attend the meeting, does the MVL liquidator continue automatically? The issue with an MVL is effectively that the intention is that all creditors will or be paid in full. However, when that doesn't happen, then obviously the duty of the liquidator is to convert the case to a creditor's voluntary liquidation to deal with it on that basis. And in which case another liquidator could be appointed, but normally the MVL liquidator converts and becomes the creditor liquidator automatically. Again, another question really about the quorum for the sort of meeting of creditors, and again, it's back to this issue that even if you've not got a quorum meeting, then the liquidator's nominee would become the default liquidator, which is normally the case. I think one of the things that it's important, and this is where it's very important when you're, calling meetings of creditors, to set up the basis correctly in the first instance and the proper resolutions. And that's why we'd always say what you want to try and do is get your committee of inspection, try and get your committee of inspection. But if you're not getting a committee of inspection, then seek to pass a resolution of the creditors with regard to a time cost resolution. One of the key point is by giving out appropriate proxy forms, both general proxies and special proxy forms, then if you're encouraging creditors to respond, then that in itself can get you a quorum meeting, because the proxies obviously count towards the quorum, and allows you to deal with it. The other thing that's important is that because the chairman of the meeting is generally one of the directors, then he can use the special proxy form, which is approving the resolution, to go forward on that basis. Another question that we've got is someone's basically saying, what if you've got the basis of your fee approved by the creditors, and the resolution is properly approved at the outset? Can you draw your fees, in advance of any subsequent final approval? Well, the answer is depends on the wording of the resolution, but the wording of the resolution that we've got in the work pack provides for you to draw fees to account. So the important point really is that there's the basis that you can be approved by time costs, but it's important to also see that you can draw fees to account, which basically would allow you to draw fees prior to any confirmation at any subsequent annual meetings. However, at that stage, there is a requirement basically to then seek approval from the creditors, by providing the information of the work that's been done, the fees that's been drawn, what has been achieved, and get that resolution basically approved at a subsequent meeting. I've had another question coming out in relation to meetings and video call after the COVID restrictions. So I think we'll take this offline, and I think the intention is that following the meeting, we'll look at any questions that we've not been able to cover, and the Institute will provide some update and response therein. So I think we've now reached our time. Thank you very much for attending. Thanks, Sarah Jane, for assisting me in doing this. And this is the end of the webinar. Have a good day, have a good week, and have a good summer. Thank you. Bye.